It appears everybody's in the room now, so I'd like to welcome everybody to our special rules meeting. I'd like to ask at this time for Councilman Lee Keener, if you will deliver the invocation.
Dear Lord, thank you for the beautiful day we've had today. Thank you for the meetings that we've already had, Lord. And we just pause and give you thanks and let you know that you are alone worthy to be praised. Father, thank you for those that are here today and help us to do the right thing. In Jesus' name, amen.
Thank you, Councilman. The next item of business is the roll call for Shelley.
Buell England.
Here.
Hillsong Baker.
Here.
Jack Baker.
Here.
Julia Coates. Here. Jody Fishingham. Here. Janelle Fulbright. Here. Don Garbin. Chuck Hoskin Jr.
Here.
Tyler Glory Jordan. Present. Lee Keener. Dick Way.
Here.
Curtis Snell.
Here.
David Thornton.
Here.
David Walkingstick.
Here.
Kara Cowan Watts. We do have a quorum.
Thanks, Shelley. Our next item of business will be under new items, new business, and we have two items today. The first item is the establishing procedures for the application of placing land into trust. And Kara, do you want to?
This is
do I have a motion?
Councilman Keener's.
Oh, okay. And ask for a motion.
Yes, thank you, Mr. Chair. Yes, I would like to put this act in front of the body as a motion. And the purpose of this act is to establish procedures to approve application for putting land into trust. And we call your attention to the bottom of the act there on page 1. So it has to be approved by the council, a 2/3 vote. And it's to put the decision-making of land into trust by this body. So I put that in the form of a motion.
I'll second.
Can we have a motion and a second by Councilman Baker, Jack Baker? Any discussion? Yes, Councilman.
Just to your proposal, I spoke with the BIA last week about putting land in trust, and they have something similar to this already in place. And if the process works like this, say a tribe goes in to put land in a trust within our jurisdiction, they all automatically contact all the stakeholders in the area, and they have the opportunity to appeal the process, this land acquisition. And if Charles Head, if he approves it to put the land in a trust, then we have the opportunity to appeal that as well. And so regardless if we say yes or no to put land in a trust, it's their decision regardless of what we say. And so by putting this act into our act or law, whatever, I'm trying to find out what's the intent or the purpose of doing so as far as on our end.
Well, as an example, I can call your attention to C under section 5, and it says that granting consent or failure to object to land acquired into trust by foreign Native American tribes within the nation's jurisdiction without the resolution required to be above should be considered a crime. So we're a legislative body here, and we also will have a process to deny or accept land into trust. So that means the executive branch can't do it, or the judicial branch can, but only we can.
But okay. Well, I mean, what I'm trying to say is like it doesn't matter if we say no, you can't do that. The BIA is going to find say so regardless of what we say.
So you're saying the Cherokee
We have no
Nation
say.
doesn't have any say?
No. I mean, we can, like, we can say no, we don't want you to do that, and we can appeal it. But in the end result, it's going to be Mr. Head, or if it goes even to a higher level, to Salazar, you know, it's out of our control. Is that?
So the BIA, in your opinion, would trump the?
Well, it's not my opinion. I called I call it Justin Fan, which is over the real estate and all that, and he was telling me the process of when tribes go to put land in trust. And like I said, they contact all the stakeholders, and then we have an appeal process, and that's about all we really have. And yeah, we can appeal it, but you know, it's.
Well, don't we want to make sure as a nation, we don't give away anything to the BIA?
Sure. I mean, yeah, we wouldn't want to do that, but I mean, it's, you know, I think it's a, we're at a high, it's a higher, the BIA regulates all the tribes and oversees all the land acquisitions that's going into trust. And so I'm trying to figure out what would be the purpose of having this into place, in my opinion.
Well, let's say if the executive branch decided to acquiesce to the BIA, wouldn't you rather have a mechanism to appeal that than just
Sure.
let it go?
Yeah, the process is great on the tribe's end. I think it's good, but I just don't. I mean, and I'm looking at the long term. The BIA is going to have the final say so after we get out of our executive session if we're going to put the land in trust or not.
Well, that may be, but we sure want to say, as a Cherokee Nation, that we don't want this, or we do want it. We want to make that. We want to make that decision for ourselves.
Okay. Well. Okay. That. Well, I'm sorry.
Jody?
I'm just wanting this in a nutshell. So basically, if somebody wants to put land in trust, we're passing the law, says you gotta ask us first. If they don't ask us first, what's the penalties for the tribe that's wanting to put the land in trust? What can we force on that tribe?
Well, nothing.
Okay, my second question is, so that's saying that nothing can be done to that tribe. We're passing a law that there's no penalty. And I'm gonna go out here on a limb and say this. Let's say there's another tribe out there that thumbs their nose at us and says, I'm putting this land in trust, and what are y'all gonna do about it? So we passed a law that we can do nothing with, and I'm just now looking at section C on here. Could you talk to me about C on here? Because the way I understand it, what this law says is if somebody on this body does not object to putting land in trust, basically you're saying that you want them kicked off the council.
Correct.
That's it in a
Well,
nutshell?
not kicked off the council, but
Well, I'm looking at it, it shall be considered a crime and a basis for removal from office.
so I guess ultimately they would be, wouldn't? But
Well, it's your
why would
legislation,
we?
isn't it?
Why would we want to give up Cherokee land? Why do we
I
just
know
want to
we
roll
want to give
over?
up Cherokee land, but I don't think we can trump the BIA on that. No, I would object all day long, but what I'm saying is, there's no penalty we can't do nothing to the other tribe.
Well, the penalty would be that we would object and they would know it, and the BIA would know it. So hopefully, we could stave off them having land in trust. If as a body, as a nation, we said no.
I'm curious, what drove this legislation? What is what I'm curious about?
Well, I don't want to go all the way back to the Cherokee history from the start, but
I don't mind, I think this is a very important subject.
Curtis and I, even today, you would think in 2011, land would not be an issue. We have the jurisdiction over the whole 14 counties. Curtis and I went today, and we were told that literally there's hundreds of cases right now where there's encroachment on Cherokee land. Not another nation, but individuals.
Mm-hmm.
So if individuals could do that, if we don't protect our land, who's going to? So if we don't use our land, we sure run the risk of losing it.
But individuals don't put land in trust.
No, they don't, but it is in trust now, but we may lose it.
I think Todd has, Todd was wanting to chime in on that, and then let's.
Yes, maybe I can be of some assistance to the council here. The act itself, what it will do is it gives a mechanism for the consent of another Native American tribe to put, in their request process for putting land in the trust within our jurisdiction. Now, what that means is this. So let's say there's a Native American tribe that wants to put land in the trust. They're going to start their process through the Bureau of Indian Affairs. and correct me if I'm wrong, there is a part of that process is that they will contact the stakeholders, which will be the Cherokee Nation would be a stakeholder in this instance. Now they will the CFRs require that that consent be given by the by the host Native American tribe, which in this case would be the Cherokee Nation. And we've had and we are in a process, and we're having and it will end up in litigation, and whether that is consent or consultation. Correct. We believe that it's consent. The word I read the CFR, it says consent. What this piece of legislation would do is say that the governing body, that when it requires the consent of the Cherokee Nation, the consent is going to be by 2/3 vote of the tribal council. It won't be by one person, the principal chief. It will not be by a court decision of our judiciary, but it will be in the legislative branch. And it will take a majority, a supermajority of the tribal council to consent to another foreign tribe to bring putting land in the trust.
Okay, stop right there for a second, Tom.
Okay.
You said by 2/3 of supermajority. Because of what he just now said in committee on Part C about kicking somebody off the council, my God, we could use I guess there's a reason to move the 2/3 to unanimous, and it wouldn't make a difference.
Well, but let me talk about point C or subsection C. It says granting consent or failure to object to land acquired into trust by foreign Native American tribes within the nation's jurisdiction without the resolution required in subsection B shall be constituted of a crime. That means that you can't do it without this resolution. You got this resolution, you can do it. So therefore, there is no, if you vote against it, you're automatically committing a crime. If you pass by 2/3 of the resolution, it is consensual. So there, just by a mere no vote does not trigger any type of criminal proceeding.
That's all.
Is that it, Todd?
That's-
Okay. Chuck? you next.
Oh, thank you, Mr. Chairman. Yeah, I'm wondering about this section C, section 5, subsection C. I've not known of an act where we've compelled, and if anybody wants to compel the executive branch to do or a frame to do something on this council, I've got to be up there in terms of wanting to strengthen this institution. I can't think of a piece of legislation in which we've actually criminalized the failure of the executive branch to do something. Not that we haven't criminalized things before. I'm not talking about our crime statutes. I'm talking about criminalizing the action or inaction of a member of the executive branch. Todd, can you think of another law we've passed in which we've said, executive branch, do this, or you've not only committed a crime, you've committed one of the highest crimes you can commit as an office holder in the Cherokee Nation? Is there anything comparable to this?
Well, as you stated, I mean, there's a number of statutes that criminalize activity, and to me, this would survive a constitutional challenge. But then again, I don't wear a black robe,
I'm not asking whether it's about constitutional challenge. It probably would. I'm just saying, I'm not saying if we said public intoxication is illegal, it's a crime. We say that.
Right.
What I'm saying is, typically in a statute, we'll say, executive branch, you do this. And if you don't do this, we can maybe get an injunction and stop you and say you can't go
Right.
forward on this. But we're saying here, we're going to slap the cuffs on you and you're out of office. To me, I know that's an important issue, but to me, this is somewhat extreme.
Well, it's not, it is grounds for impeachment, not necessarily impeachment. Again, impeachment would take which we will discuss, will take a 2/3
Impeachment Act
majority.
we're about to discuss?
Right, exactly.
I mean, you get a simple majority on this council and you're there, according to this legislation. I know we're getting to that next.
We'll cross that bridge, but the fact is what would criminalize this is that if there is an application by a foreign Native American tribe to put land in the trust, and we've gone through the process, and that resolution, through this statute, if it were to pass, and when you failed to get the resolution, you failed to get that 2/3 majority, and then the principal chief does it anyway. Well, then that's when it would trigger a criminal activity, okay? Where basically you're disobeying the laws of the Cherokee Nation. So I believe it would survive as constitutional challenge, but, this is the legislative process.
Couldn't we get there if we just said that this will be subject to injunctive relief? I mean, couldn't we stop short of slapping the cuffs on an elected official?
As I said.
Wouldn't we get effectively the same policy?
You would get the same result, yes, which is to stop the matter. And again, like I said, this is part of the legislative process.
Would the councilman accept a friendly amendment to strike this business about criminalizing this activity and inserting a section that says we can obtain injunctive relief to enforce any provision of this statute? Because essentially you go into court and say, Judge, Chief of the Cherokee Nation just signed off on or refused to object. And I'm not sure when that comes up. Is it the moment he sees it in the paper or the moment we get notice and we don't object? Within what time period? An hour? 2 hours? At what point does it become a crime? But I think that points out the problem with criminalizing this. I wonder if you would strike that section and say it's subject to injunctive relief, any provision of this article in the courts of the Cherokee Nation. I mean, wouldn't that get you where you wanted to go and maybe avoid some of what I think will be pretty thorny problems if you criminalize this, especially when you criminalize the failure to take an action, Councilman. If you criminalize the failure to take an action, at what point has the executive failed to take an action? I mean, that's a very important question that this legislation doesn't answer, so I'd urge you to accept that friendly amendment and strike this section.
If it would hold the Cherokee Nation together, I'll accept that.
Okay, thank you. So I've made the friendly, he's accepted. Did the second accept?
I would remind the councilman that I immediately, when you asked, have we criminalized this before, if we could ask Doublehead or Major Ridge or John Ridge or Elias Boudinot if there's any penalty for giving up land.
Thank you,
That's pretty
Councilman.
severe.
Appreciate that.
Let me make sure I have the correct here. All right. What I would have is on subsection C, strike the language after B, and then substitute the language shall subject the officer to injunctive relief through Cherokee Nation courts.
Good enough.
Can we read that one time, please?
I'll read it in toto here. Granting consent or failure to object to land acquired into trust by 4 Native American tribes within the nation's jurisdiction without the resolution required in B shall subject the officer to injunctive relief through Cherokee Nation courts.
And as a second, I will accept that. I didn't officially state that earlier.
Should we have Shelley read that back, because make sure she has it ready?
Sure.
Yeah. She's got it.
Got it, all right.
Okay, moving on, Ms. Watts.
Thank you. I think that this goes more towards a similar act in some way about, as we become a more sophisticated government, strengthening the legislative branch's involvement in decisions being made for the Cherokee Nation. I believe it was Councilman Hoskin that brought forward an act about the naming of Cherokee Nation buildings and the involvement of the legislative branch down to the details of the naming of a building, and to make sure that we were involved in that decision-making on behalf of the Cherokee people. And those things are important, just like this act is extremely important. Our land base is the fundamental land for a sovereign nation is critical. We know that. I think the blood laws that were spoken to earlier, historically, we know how important land is to the extremes that Cherokee Nation and Cherokee people will go to protect our land base. And I think that's what this is about. It's about the legislative branch being involved with very critical decisions for the Cherokee Nation in our future, which involves our jurisdiction and the protection of those sovereign boundaries. It doesn't make it criminal unless they ignore the need for the protections of our land and ignore the involvement of the legislative branch. Saddened that we don't take it to that extreme, because that's how important this is. It should be for all of us. But I understand and we'll accept that we'll just have to go to court if that's the case. But I hope we pass this today, because this isn't about any individual, it's about something greater than all of us. It's the protection of the Cherokee Nation. Thank you, Mr. Chair.
Thank you, Ms. Watts. Julia Coates next.
I want to echo what Councilor Watts has said. I am interested in Councilor Hoskins' remarks, which sort of, you know, as we all know, legal questions can come, you can come at an interpretation from many different perspectives. To frame this as criminalizing the executive for not doing something is sort of coming at it from a negative perspective. I view this legislation from an affirmative perspective, that it is a legislation that is giving this tribal council, this legislative branch, standing in this very, very critical issue. Should we need that at any point in the future with our courts or with the federal courts or with the Bureau of Indian Affairs vis-a-vis the Bureau of Indian Affairs? And I have heard Mr. Hoskins for many years now argue again and again that the executive branch should not be the only branch of government that has authority to do any number of things, and this would provide the legislative branch a degree of authority that we presently do not have, it appears, in this particular matter. I agree that historically the relinquishment of land has been treated as the most severe crime that a person could commit in this nation, with the most severe penalty that we ever enacted. That is historically the value that we have placed on our land and the penalty for relinquishment. And I think to do any less, I actually don't agree with the friendly amendment, because I think to do any less than criminalize this for anybody who does this is an affront to the legacy of our ancestors and their continuing struggle over many, many centuries to hold on to every single inch of land that we had. I also do not agree that the BIA regulates land into trust or these other kinds of issues. They like to try to do that. But we had a situation almost 20 years ago where not land but jurisdiction was transferred away from this nation and to another, being formed at that time by an administrative decision of the Bureau of Indian Affairs. And the Cherokee Nation appealed that into the federal courts and won a judgment from the federal courts in that issue against the judgment that the BIA had made. So the BIA is not the ultimate arbiter of this issue. For all of these reasons, I think that this is a very, very important piece of legislation. Although I don't agree with the weakening of provision C in this, I still think this is important enough that I will vote to go ahead and pass it. Thank you.
Thank you, Ms. Coates. David, you're next. David Thornton.
Okay, I agree totally with the degree of authority that Cherokee Nation or the legislation branch should have, but I would like to have Todd come up and just explain in layman's terms the change here that we've had.
The change would be this. It takes out any references to automatically criminalizing an action or non-action, and it says that that the council would have standing to go to court and to ask for a writ of injunction, or writ of mandamus, to prevent the consent by any officer of the Cherokee Nation without first getting the 2/3 resolution required under this act. Basically would give a standing to go to court. Not, any member of the council, I would say, would have standing to go to court at that point.
Okay, I'm really glad that was stricken, that part. I was sitting here thinking that, I may have to be asking Mr. Hoskins to represent me in this, for free or something of that nature. I'm sure he would do it, I don't know. But, it kind of gets to me when we go to trying to kick someone off of this council, and especially by just a majority vote. I'm not for that. I'm pretty sure we need two-thirds, and I think that's by the Constitution, if I read the Constitution right. But anyway, I want you all to remember back a few years back, when the Choctaws come across the Arkansas River and they took over Blue Ribbon Downs. I just wondered what would have happened if they would have tried to put Blue Ribbon Downs in their trust land. But I don't really like just a nation coming in to our nation and acquiring land. I don't think any other nation should be able to buy land in our nation, and I think we need to do something with the BIA to stop that. And that was utterly ridiculous, and I'm glad that they went broke over there and lost $2 or $3 million a year and had to give the darn thing up. And because I know it went over, it stormed down there every year and blew those barns away, and it hadn't stormed since. So that little rain dance I was doing down there helped. So that's one of the things. But this crimes against council people, we need to check into the code book and look on the old code book, volume 1, on page 325, where it is you do have crimes against council. And when you try to stop a councilman from making a decision, and you're causing a crime right then. So whether he votes yes or no, that should be his business. It shouldn't be anybody else's. Thank you.
Thank you, David. Chuck?
Just briefly, Mr. Chairman, and I appreciate.
Oh, I had one more deal.
I'll yield to him if he'll yield back.
One more question, that was to Mr. Walkenstick.
Yes, sir.
The answer that you got from the federal government at the BIA, did you get it in writing? They wouldn't send it to you? I find that out all the time. They quote different things to me, but they never put nothing in writing when I've asked them to. So next time, ask them for something in writing.
I'll do that. Yes, sir.
Thank you, because I'd like to see it.
Okay. All right.
Mr. Chairman, on a point of clarification, if you will, again, the language about criminality has been stricken. And even in the original language, it would not have required it without if you got the passage of the resolution. But I just wanted to make that point.
David, you clear on that? What he just said, it had been stricken, that language that you had. Chuck, back to you.
And just briefly, and I appreciate the commentary on strengthening the institution. I do believe in that. When I look at this and saw that we were going to criminalize the inaction of another branch of government, it did give me pause. I realize that's been stricken down. I appreciate the councilman. I think that's a reasonable approach. The other thing is it strengthens this institution. What it really does is it strengthens a minority of this institution. It takes a minority of the council can effectively check action of this sort. Now, I never thought we ought to put land in trust with a foreign tribe. I've never thought it was an issue. In fact, I think it was a manufactured issue during this last election. But to the extent it is an issue, I haven't met a council person who thinks we ought to put land in trust from a foreign nation. But in any case, when we talk about strengthening this institution, what we've really done here today, if we pass this, is we've strengthened a minority of this council that will effectively veto any sort of land like this into trust. If we can't get 2/3, then it's not going to happen. Not only is it not going to happen, you can go into court to stop it if a chief of the Cherokee Nation tries to, skew this act. So anyway, that was the only problem I had, Mr. Chairman. Thank you.
Thank you, Chuck. Dick?
Thank you. Lee, I was not going to support this legislation until the friendly amendment was taken by. Thank you for doing that. And I appreciate that. And in fact, I'm not going to make a friendly amendment to such, but I would even say now that that's been stricken, 100% of council would have been what I would have liked, even though I'm not going to make that friendly amendment. I agree with you, we need to protect the tribe and the land base with blood if necessary.
Thank you. Jody?
I was gonna ask a simple question about the two-thirds lead. I know our impeachment act requires two-thirds and all the rest of our acts are a simple majority. And I was curious about why you come up with the two-thirds.
Well, as Councilor Lay said, I originally maybe could have made it unanimous, but dropping down from there, two-thirds was the next best.
Okay, thank you.
Okay, Kara.
So just to make sure that all minds are clear, whether there was criminality involved or the injunction part, this just engages the legislative branch in the decision-making process so that all of our votes would be on the record, or all our actions would be on the record, so it'd be clear for the Cherokee people. It doesn't hinder anybody saying that if they voted yes or no, that it would do anything to them. It would just require that we actually take a vote and participate in that decision-making process. And if the criminality had stayed in, it was for other people allowing that to happen without our involvement, which would not have been any council people. So I just want to make sure that was clear for the record, because there was a lot of statements that could quickly become something that this is just not. So thank you, Mr. Chairman.
No other questions? Oh, okay, David.
Well, this back to, now that I'm got a good understanding on this act, you know, instead of having the chief by himself to deal with the BIA in the appeals process, it'll come to the executive branch, and we could, legislative branch, and we could just talk and reason out and get our consensus on it.
Are all minds clear? So we'll have a roll call vote on this, shall we? Shall we do a roll call?
Jody Fishing-Hawk,
Yes.
Janelle Fulbright,
Yes.
Don Garvin,
Yes.
Chuck Hoskin Jr.,
Yes.
Tina Gloria Jordan,
Yes.
Lee Keener,
Yes.
Dick Clay,
Yes.
Curtis Snell,
Yes.
David Thornton,
Yes.
David Walkingstick,
Yes.
Kara Cowan Watts,
Yes.
Bill England,
Yes.
Bill John Baker,
Yes.
Jack Baker,
Yes.
Julia Coates.
Yes.
We have 15 yes and 0 no.
15 yes, 0 no. Passes. Okay, our next item is item number 2, 11-120. This is an act revising Title 51 impeachment. I'd ask Council Lady Cowan Watts.
Thank you, Mr. Chairman. In reviewing some of the law with a question that had been asked of me as the acting speaker, our attorney, Councilman Hembry, discovered that in the middle of the codification process that the impeachment code had not been updated per the 2003 Constitution. And so to keep up with the codification process and make sure that this isn't left out, we should pass this. It is simply a reiteration of the current Constitution that we operate under today, that was under the 99 Constitutional Convention, passed in 2003 by the Cherokee people. And it sets out the additional policy or process of what will have to happen should this unfortunate occurrence actually coming forward for us. And I would make a motion with one amendment, that under definitions, the special prosecutor, which is on page 2, section 4A, for definitions, would also include and be admitted, it would be admitted to the Cherokee Nation Bar in addition to the highest court of the state. So we would add that they'd be admitted to the Cherokee Nation Bar, and I make a motion to pass
Pass it with that one change.
with that one change, yes.
Okay, you have a second, Lee. Any discussion? Okay, Chuck?
Thank you, Mr. Chairman. Todd, I have a question for you.
Yes, sir.
You're in the middle of codification. You've been doing codification for probably
Far
the whole
too
time
long.
I've been on the council. Right?
Yes.
And where's the end point? When do you think you'll be done with codification?
Well, we'd hoped to be done with it in May of this year. as you know, we've had the summer of 2011, which none of us will ever forget, that has caused a delay in the codification priority. But hopefully, we will fire that engine back up and get it going, and I'm going to say 4 to 6 months.
Okay, so 4 to 6 months, you'll come to us with essentially a report, I assume, which will say, here's the statutes that need to be cleaned up.
Correct.
Through the process of codification. In fact, that's why we tasked you with codification, is so the really cumbersome process of finding all of these defects can be brought to us in a comprehensive manner, and we can act on that. I think that's why we sent you out to do that. So my question is, why, at this day, at this month, are we picking out this particular act to take action on when we've got a whole host of things to clean up in 4 to 6 months? Maybe I'm asking the wrong person, but do you know the answer to that question?
I do what I'm told, sir.
Well,
I mean, you know, I'm not trying to be flippant, okay?
No, I understand.
You know,
I expected that to be the answer,
Yeah.
because in fact, your anticipation was, I don't want to put words in your mouth, but in 4 to 6 months, you'd come to us with a comprehensive list of statutes that were defective for whatever reason, that needed action through the process of codification. We would get to that when we got to it, because you were in the process of doing that. That's what I anticipated. Would the chairperson, would Councilor yield for a question, the sponsor?
Sure.
Why now, Kara? Why this legislation now, when we've got 4 to 6 months worth of work ahead of us for all sorts of statutes that might be defective?
And we do have a significant, I don't know where the councilman or counselor, our attorney, we have a significant amount of work ahead of us. And there's stuff I can't speak to, but I was advised that we need to move forward with it. And
well, and that's one thing on the reason for my memorandum, is that we are to debate the merits of the act alone.
Well, I know
Yeah,
you recommended
and-
that,
yeah.
but the fact of the matter is, it just puzzles me that we plucked this one out. And it carries with it so much rumor and innuendo necessarily. So when you pluck this out of a process that was in the middle of the process, when you pluck this out of a process that was 4 to 6 months to the end, which 4 to 6 months in the scheme of fixing statutes is not that long, I just wonder why. And I know you can't answer why, because your answer to why is because that's what I was asked to do. And the councilwoman's response raises a ton more questions than answers. So it troubles me that we're even here. But since we're on the substance of the legislation, Todd, this calls for a simple majority to trigger the impeachment process. Is that correct?
That is correct.
Now, that's the way the old statute read.
That is verbatim from the 2002 statute.
Is that comparable to what you see in a lot of states and in the Congress of the United States?
I'm not prepared to answer that question, you know, about the initiation of of articles of impeachment. I do know that articles of impeachment in the House of Representatives begin with I want to say the Judiciary Committee, but I can't tell you if that requires a majority or a 2/3 vote. I don't know.
I think the answer to the question is yes. I think that it's a simple majority, but in those governments, you have a bicameral legislature where you have the one body that's going to be filing these charges, and you have another body that's going to be deciding whether the person ought to be kicked out of office,
Correct.
House and the Senate. Here we've got the same group. And so my thought is, why do we have the bar lowered so low? I mean, shouldn't we raise this bar? I mean, this is a very significant action. I mean, you're talking about targeting someone for an impeachment with just a bare majority, which carries with it a tremendous amount of legal costs, tremendous disruption to the government. It seems to me the bar ought to be a little higher. So in some ways, maybe it's good that we're looking at this. I thought we'd look at this eventually. I just didn't think it'd be now, and I'm puzzled why it's now. But if we're looking at it now, I suppose we ought to try to fix it. And one fix I would suggest at least discussing, I don't know if we're going to make it a motion right now, is why not make it 2/3 to initiate the impeachment process? Since we're the only body that's going to be involved in the impeachment process. It's not as if we can kick this off to some other branch of government to decide. We're going to be actually deciding this in the second instance, in the first instance, in the second instance. So it seems to me we need to raise this bar, and that's all I have right now, Mr. Chairman, just kind of food for thought.
Ms. White?
so if there is, I'm not opposed to considering, because we just needed to technically amend this to update for the current constitutional language. That was the only question that I was hoping to bring forward today to make sure that we could keep moving and have our house in order. So if,
Order.
Mr. Chairman,
Yeah.
there was a statement from the audience. Would you please, that was not of decorum to this body. Please strongly advise the audiences that if they are going to remain in here and participate, they're going to do so in an orderly fashion and not make any type of statements that will be detrimental to the running of this body.
Thank you, and I don't know where that remark came from, but please refrain from doing that in the future. If you're gonna sit in this room with elected officials like this, you keep your thoughts to yourself and do not outburst like that again, or you'll be escorted out with a marshal. Thank you.
Thank you, Mr. Chairman. So I think that we should look at, does parts of the code need to be updated? Because if we were to go through this process in a real manner, which would reflect on our body, regardless of who made what choices, and it's not something I would want to do. And when I had to go look at the act to consider, what does the 2003 Constitution say? What are our past policies? What would our current policies be? The only thing that I would struggle with is how you kick off who would be the investigator, because the way I understand the special prosecutor doesn't mean that somebody's impeached, because that takes a 2/3. So back to, I think, earlier discussion, a small minority could stop that from happening with the 2/3 majority requirement. But if you actually had to have something investigated so that that person could be vindicated or proven otherwise, or however that works out, to sort the facts out, right now you would be putting someone, because it speaks to this in the special prosecutor definition, that it wouldn't be someone that's an employee of the Cherokee Nation and those kind of things. You would be putting other people at risk. So I know as acting speaker or any individual of this person of this body, I would not want to be the one doing the investigating. So if we don't have a way to kick this off that's reasonable, if there were such an incident arise, do we give that authority to the FBI? Do we give that authority to the BIA? Would we ask the AG who we confirm to do that work? That becomes problematic. So I think it's why there's a simple majority to kick it off as in the past, and I don't know that this body's ever had to do such a thing. But I'm not opposed at all. I think we need to have this discussion, because setting the rules and procedures around this with the current constitutional language is extremely important, and I think we need to have our house in order. Thank you, Mr. Chair.
Thank you, Ms. Watts. Jody?
Todd, would you define some of these terms for me, please?
Yeah, I'll do my best.
Okay. I'll give an example. Define neglect of duty.
No, well, neglect of duty, in layman's term, is not doing something that you had a affirmative duty to do. Not doing something that you should have done.
Example.
I am supposed to provide for the welfare of my children. And if I don't do that, I'm neglecting my duty to them. Okay.
Corruption in office.
Corruption obviously has its own definition, and also as if you're an elected official or an appointed official, according to the 2003 Constitution, you perform an oath. You take an oath when you're duly elected and sworn in. And that oath calls for you to do many different things, and that really goes back to neglect of duty, but also corruption. When you become an officer of the nation, your standards are higher than any other average citizen of the nation. And when you do acts that may not even be criminal, but it's corrupt, it could be grounds for impeachment.
Who makes that call? I'm curious.
Well, eventually, it would
It's a
be,
judgment call.
yeah, it'd be this body. At the end of the day, it'll be this body by a 2/3 vote.
Is there any way to put a definition on people's judgment calls?
No, that's why people have their free will to judge.
Okay, habitual drunkenness, that'd be.
You get drunk all the time.
I mean, I can see somebody, let's say we go up to Hard Rock, and there's, somebody drinks up there 2 or 3 times, is that a habitual drunk?
That is a term of art that has been rolled over for the impeachment of officers in a number of constitutions, and it really has its origins in the Prohibition days, whereas that a person could not effectively run office if they were habitually or all the time intoxicated. So therefore, yeah, it's a term or it's a definition that has been from a gone by era. But at any rate, it's there. It's part of our Constitution.
Incompetency, because I remember on another act, I do believe it was Chuck Hoskins that cleared that up and put a definition in there, was it not? Because there wasn't a definition? We didn't match the new Constitution or something?
You want to yield just a little bit of time?
I think it was incapacity or disability, something like that, but it is a good comparable. Those terms are hard to define, and I think any one of us probably have been labeled as having fit that definition a time or two on this council, but so that's why it's difficult for me to understand how we define that.
Well, that's what I'm leading up to. Talk to me about moral turpitude, Todd.
Moral turpitude. In all these definitions, it reminds me of a.
Well, I'm not finding them in the act, though. That's what got me.
No, and you won't, because they're hard. They're hard definitions to come by. And this is a little off color, but not too much. But it's when asked, how do you define pornography? Well, I don't know, but I know it when I see it. So I mean, it's a type of situation that a lot of these things are going to be judgment calls. Of what is competent to one person may be incompetent to another. But that's why it goes through the trier of fact, which would be the court in this case, which would be the tribal council by a 2/3 majority. Now, to get to your to definition of moral turpitude. Moral turpitude, I knew that's one that would be coming up. Black's Law Dictionary defines moral turpitude as the act of baseness, vileness, or the depravity in private and social duties which man owes to his fellow man or to society in general, contrary to the accepted and custom rule of right and duty between man and man. That same definition it has been adopted by the state of Oklahoma in a case that I've looked up. Again, it is a judgment call. What is moral turpitude? These things, some of the greatest legal minds cannot come to a consensus or agreement as to it. It is, you know it when you see it.
Okay, it says, or a misdemeanor involving moral turpitude. So I asked somebody, and I know another person that has a lot of dealings with the state, said, some judges can define it as straightforward as a speeding ticket would be a misdemeanor involving moral turpitude.
Well, and I would disagree with that judge's interpretation.
That's what the Oklahoma Insurance Association said.
But did you get in writing? No. It's moral turpitude is something more than just mala prohibita. I got to use a good Latin frame there, term there. Mala prohibita. It's something more than it just being against the law. It is something again that shows depravity, that shows a baseness of action. But that's not to say that some things have some simple things have not been determined to be moral turpitude. There have been cases where it says that knowingly producing a bad check can be a crime against moral turpitude. Fraud against estates can be moral turpitude. It is again something that is hard to define, but it really depends on the circumstances and the level that a person should know. Example: there are tons of cases, and I'll probably get a laugh out of this, involving moral turpitude against lawyers. Okay, But that's because we should know better. We should know better than to defraud our clients. We should know better than to play fast and loose with an elderly person's estate. That's why, again, we're held to held to that standard. I'm not going to I can't give you a universal definition on these terms because they don't exist. They are what based on their circumstances and the individuals that are involved.
And the last part says, or offenses against the Cherokee Nation committed while in office. And maybe I'm being a bit of a smart aleck here, but a lot of this reads, I woke up this morning and I don't like you.
Yeah, that could be it. If 2/3 of everybody agrees that they don't like
Yeah, 2/3
you.
woke up on the same time of bed. Who'd have thought that?
Yeah.
No, right now it says 8, it's just at a simple majority, isn't it?
To start the proceeding, which would be to appoint a special prosecutor to look into an accusation to see if there is material there that would warrant an actual impeachment trial.
Which brings me to the next question. It says the special prosecutor shall investigate these charges and any other transactions. So when we appoint a special prosecutor to, for lack of a better word, look at Tina, while he's looking at Tina, he can actually look at all the rest of us for something else, couldn't he?
I don't know.
Well, would you read that part? You tell me if that's what it says. Special prosecutor shall invest those charges and any other transactions. So it's kind of like grand jury?
Could be.
Okay, and these impeachment process could be started by a majority of the council, or the following paragraph says, or the principal chief can do it.
That is correct. You don't want to leave it all to one branch.
So it's left to one branch and one man.
Well,
So,
for instance,
For instance, acting chief president could
Sure.
start him on his own.
Absolutely, you could under this act. Because if you want more eyes looking at each other, you don't want just a council who would never, who in theory would never initiate an investigation on their own. You would allow the other executive branch to start that.
Well, I'm just using it for example, but that's what it means,
Yeah,
the majority
absolutely.
of council or the chief, like Bishop,
Absolutely.
principal chief president could start him tomorrow.
Yes.
Okay, and if they are acquitted, they get their attorney fees to be taxed by the clerk and paid by the Cherokee Nation out of any funds available. So they will get their fees back if they was to be.
If they go through the process and they are acquitted, they will be made whole.
Okay, I was about to say, is there any way in here you get your reputation back? Shouldn't we put a payment in there for that? After somebody brings these up?
You get your attorney fees back if you're acquitted.
But we could add a part of it. Could we, could we not?
Well, you can make any amendments to the piece of legislation that would pass constitutional muster.
Okay. I'm through.
Okay, we're down to about 30 minutes before full council, so, and I've got 4 names on the list, so let's try to keep it real brief. Lee, you're next.
Well, just to put it in a historical perspective, and correct me if I'm wrong, but I think the only time there was ever an impeachment, and I don't know if it was 2/3 or unanimous or what, but it was W.C. Rogers in 1905, and the legislative body did impeach him because he was signing away the Cherokee Nation right at the time of statehood. But the federal government did not recognize it, and he stayed chief till 1917. And then until he died. I just wanted to throw that in there for historical perspective. Thank you.
You're next.
Thank you. So, the Constitution stands as is our supreme ruling document. So I have a couple of questions. The first question is if someone is found guilty that's a seated official, which doesn't include just elected under this new Constitution, they would actually be automatically removed because they would no longer qualify for office if it was a felony.
Yeah,
Or equivalent.
after conviction by 2/3 vote in the council, you would lose your office, yes.
And it's nothing about personalities or whatever this is being misconstrued as for the 2/3. So then what happens if this is not updated, if we have to go through some kind of process, what happens?
Well, I mean, the act right now is unconstitutional because is under the auspices of the 76th Constitution. You know, if you're going to use this process, you will have to update it at some point. You just have to.
Okay, thank you. Thank you, Mr. Chairman.
Tyner, you're next.
Well, I'm just gonna make a few comments because I see a lot of holes and a lot of work that we need to do with this particular act. Right now, we leave the right of recall by our citizens of any public official that they have elected that they have become unhappy with. The people enjoy that right, and they are the people that have put us in these seats. And the way I read this, basically by 8 people sitting on this council, they can initiate through whose choice I'm not real sure of, who would decide who the special prosecutor would be. They could initiate some allegation against any one of you all sitting here, or your chief, or your deputy chief, and say we want them investigated. And possibly after thousands of dollars that they have spent trying to protect their reputation, they may be found not guilty by this very body. First of all, we only have here in this act that they only have to meet the standard of clear and convincing, which is a lower bar than you have to meet in, say, a criminal trial where you're removing someone's freedom, which is beyond a reasonable doubt. And I would ask this body to consider that the level needs to be raised higher. It shouldn't be left to a mediocre bar of clear and convincing. It should be raised to a higher bar of beyond a reasonable doubt. I think when somebody's reputation is involved, it shouldn't be a simple majority, because I think with a simple majority, it could lead to just politics being involved. So I think that we certainly need to consider raising that bar of 2/3. Now remember, this is something this body's doing, not the people that elected us. If the people become unhappy with us, if the people see us do something out in the public setting that they're not happy with, they retain that right to, by petition, remove us. The other part that I'm really concerned about is all of us sitting on this jury, because part of us sitting on this jury will maybe be the ones that have actually made the allegations against us. So they're witnesses, and they're also jurors. It may be that we try to remove the chief and the deputy chief, and if we do that, that would mean a speaker or deputy speaker might move into a position that's higher paying and more power. Should they be sitting on a jury that will participate in the removal of an individual where they will receive something advantageous in return for doing it? If you're a juror in a regular setting, you need to be a juror that is beyond approach. You come in with a clean, clear conscience, having made no decision about the case because you know nothing about the case. We're not jurors going in with clean hands by any means. Several of us will have made the allegations. Several of us can personally benefit from the decisions. So this act needs a lot of work in light of the fact that we have a new constitution. We now have new positions that we didn't have before under the old constitution. And those are just a few things that I've noticed at this point, and I would suggest to you that we need to do further study before we pass this. I certainly think we need to raise that bar to 2/3 if we don't do anything else to this act. But I would make a motion that we table it this time and consider it at the next meeting, a full meeting.
Second, if that's at rules, so we can continue to move on it before codification.
My suggestion is going to be that we not do it in the next rules meeting, that we take some time, we even form a subcommittee to talk about this. The people still retain the right of recall, folks, and to me that's the greatest right that we can give to people. We don't need to rush into a half-baked idea of what we want to do with impeachment if we've got a problem, the people will take care of it. I have faith in them. They have put all of us in the office. They can certainly take us out. This needs to be a subcommittee needs to be formed, and we need to look at each and every word of this act before we contemplate its passage. So I put that it, my motion will be that it's tabled and it goes to a subcommittee.
If
Second.
the councilwoman is clarified, I accept.
Okay. Okay, we'll vote on whether we're gonna table it or not to
A
the
subcommittee.
subcommittee.
Table to the creation of the subcommittee. And at your next rules meeting, you would create the subcommittee.
Is all minds clear?
Yes, just take-
Do a roll call.
David Thornton,
Yes.
David Walkingstick,
Yes.
Kara Callan Watts.
Yes.
Bill England.
Yes.
Bill John Baker,
Yes.
Jack Baker. Julia Coates,
No.
Jody Fishinghawk.
Yes.
Janelle Fulbright. Yes. Don Garvin.
Yes.
Chuck Hoskin Jr.
Yes.
Hannah Gloria Jordan.
Yes.
Lee Peter.
Yes.
Dick Clay.
Yes.
Curtis Snell.
Yes.
We have 14-1.
14-1, it'll go to the subcommittee. And that's the last item. Any announcements? Full council in about 20 minutes. Anybody want to adjourn?
Second.
All in favor?
Aye.
Adjourn.